In Brunswick, Georgia, all the evidence and some of the arguments have been made in the death of Ahmaud Arbery murder trial, and soon the case will be in the hands of the jury.
They shot and killed Ahmaud Arbery. They all acted as a party to the crime.
Ahmaud Arbery was not an innocent victim.
But there's still no false imprisonment here as a matter of law.
We're talking about probable cause. Totality of circumstances.
We are live in Brunswick with the latest.
This jury appeared engaged, alert, and thoughtful as they heard closing arguments from the state and defense. Will have how much more they have to listen to before they can go to deliberations, and the moment in court that sent Ahmaud Arbery's mother out into the hallway.
On the docket tonight in Hennepin County, Minnesota, the shooting death of Dante Wright. Former officer Kim Potter yells, "Taser, taser, taser," but shoots Wright with her service weapon. Was it an accident or was it a crime? In tonight's Unsolved Case File, the murder of Dominic Arca-Jones. On October 20th, 2018, Dominic was shot and killed just blocks from his home. Tonight, we ask for your help in getting justice for Dominic's family.
We have no closure. And right now, I mean, we know he's gone, but it still felt like he should be walking through this door.
And more reaction tonight to Friday's dramatic conclusion to the Kyle Rittenhouse trial. Tonight's 13th juror question: what did you think of the jury's not guilty verdict? Go to our Facebook pages and tell us what you think. This hour of closing arguments starts right now. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments, and coming off of a huge week last week and a big Friday night. Everything that happened out in Kenosha still reverberating tonight. We're going to talk about it a little bit later. But right now, here we are now in closing arguments in another huge case in Brunswick, Georgia. The shooting death of Ahmaud Arbery. 3 men on trial for murder, all facing life in prison. Today, the closing arguments in this case. And this is a case also that involves an allegation of self-defense. That's part of the defense here, self-defense. But we are really sitting here with a much different situation. And I just want to take a step back, okay? Yes, we're going to dive into the legal standards and the specific facts of the case and really get into the weeds. But I want to take a step back, because from my experience, you need to take that step back in a self-defense case. Because that visceral reaction that you have to a situation, I think, is the same visceral reaction that a jury has. You look at a death, a shooting death, and you look at it and you say, okay, well, someone is alleging self-defense here. Well, who started it? Who started it? That's not a legal standard necessarily in those words, but I think that's the way most of us look at these self-defense allegations. I think it's the way many jurors approach them as well. You know, there's a confrontation, someone is dead, the person who killed the other person is alleging self-defense, but wait a minute, who started this whole thing? And we know what the jury found in Kenosha, and it was consistent with what the video showed us. That yes, there were people. Everyone shot by Kyle Rittenhouse was chasing Kyle Rittenhouse. Everyone shot by Kyle Rittenhouse initiated the confrontation with Kyle Rittenhouse, as shown by the videos. Let's move to Brunswick, Georgia. What do the videos tell us? Who's chasing who? Who's initiating the confrontation? Who is starting this whole thing? And I think that's important, an important distinction. Now, let's break it down, get into the weeds, okay? For the defense here, there's really 2 huge hurdles they need to get over. You don't start with self-defense. First, they've got to justify this chase, because it's clear on the video who's pursuing who. The justification, the alleged justification in this case for the chase is the citizen's arrest law. And that was argued today in court, both sides in front of the jury, in closing arguments. Take a listen. I'm going to play for you the prosecution, then the defense.
Citizen's arrest. This was not a citizen's arrest. not present when any crime was committed. The suggestion that Ahmaud committed a crime is based on what? Not immediate knowledge, speculation. Speculation. How do we know? Because of the defendant's own words to the police. That's how we know. Wanting to question Ahmaud demonstrates uncertainty. Hey, where are you coming from? They don't know where he's coming from. What are you doing? They don't know what he's doing. Remember, Mr. Bryan? Heard, what'd you steal? Okay? They don't know what he's done. They don't know why he's out there running. They don't have immediate knowledge. They have no knowledge. They have speculation because he's running down the street. Wanting to question Ahmaud demonstrates a lack of immediate knowledge, which is required under the citizen's arrest law. Because it's required, that means this was not a lawful citizen's arrest.
Travis had all of this. His reading Facebook, everything going on at Larry English's house, knowing about what was happening in Satilla Shores, speaking with everybody on the 11th, his own experience, Albenzi signaling, Officer Rash and Matt Albenzi. This is what he carried with him when he left his driveway that day. Reasonable and probable grounds of suspicion. Reasonable and probable grounds of suspicion. Facts and circumstances to warrant a prudent person, one taking care to understand the truth. In believing that the suspect has committed the offense of burglary. Travis believes he's committed the offense of burglary. The facts necessary to establish probable cause for arrest are less than those required to prove guilt beyond a reasonable doubt. It's more than suspicion or possibility. It's got to be a probability, probably. And he said, I had a probability. There was a probability that this was the guy who did it, and here's why I think he did it. And I wrote down every one of the things that we talked about as he testified. I wrote them all down, and they are all encapsulated in that slide I just told you. This is where the duty and responsibility in following the law becomes intertwined with heartache and tragedy. Because you do have the right to perform a citizen's arrest. You do have the right to have a firearm when you make an arrest. You do have the right to stop a person and to hold them and detain them for the police.
Okay, as you know, there are, in cases, in trials, there's the facts and there's the law. Sometimes you argue the facts, sometimes you argue the law, sometimes you argue both. I'm trying to really focus in on where the difference is and what this jury is going to have to figure out as it pertains to citizens' arrest. So I've got to bring in Court TV legal correspondent Julie Janae, who's in Brunswick, Georgia tonight. She knows all the facts of the case that both sides have argued. She knows the law. So let's start there, Julie Janae. Are these two sides agreeing in their arguments as to what the legal standard is? Is it just that they're arguing a different interpretation of the facts here? Explain to us the difference between what prosecutors are arguing to this jury and what the defense is arguing as to citizens' arrest.
Vinny, there is a difference in their interpretation of the law. So not even getting into the facts, but when we're looking at the citizen's arrest statute and the two prongs that are required there for understanding that a crime has occurred, it has to be either in the presence of or in the immediate knowledge of. So one or the other. The state views this as one and the same, and they gave the description today or example of a security guard who is yards away from where the shoplifting is happening, but they are looking at screens and monitors from the security camera, and they have immediate knowledge that someone has stolen something because they see it, but they're not in the presence of. The defense, however, says it's not one and the same, that in the presence of is when you physically are there and you see a crime happening, but immediate knowledge can be at a different time. And it can be that you have probable cause from other information that you have gained, and that is still part of citizen's arrest. We even heard Franklin Hogue, the attorney for Greg McMichael, today standing up in the middle of the opening or closing argument, rather, for the prosecutor to object when she was explaining to this jury that those two prongs are one and the same.
So what is the judge going to tell the jury about this issue? Because that's who they're going to look to ultimately for guidance, right? Jurors trust the judge. That's the judge's job. What is this judge going to tell the jury about who's right? Is it the prosecution or defense?
You know, the jury is going to get these instructions, and they're going to get a citizen's arrest statute that is going to read, just as I said it, immediate knowledge or in the presence of. They won't necessarily get a definition of immediate knowledge. They will get that contemporaneous arrest instruction, and we understand it's been modified some over the weekend, where the prosecutors wanted to tell this jury that any immediate knowledge or reasonable, probable suspicion has to come at the same time of the crime that's being committed, and someone has to carry out that citizen's arrest right away. They can't wait until later. But our understanding from the defense attorneys is that the language has been modified to allow this jury to take into account, or see it from the defendant's perspective, that they are allowed to take into account other things that have happened prior to, which is important in this case because Travis McMichael had that encounter with Ahmaud Arbery 11 to 12 days before the actual incident of the shooting, and he wants to be able to use his understanding and the things that he learned 12 days before as to why he was trying to carry out that citizen's arrest on February 23rd, 2020.
This is so incredibly huge. And it seems to me we're almost asking, in this instance, Julia, the jury is making an interpretation of the law to a certain extent.
You know, they looked at the judge when there was that objection by Franklin Hogue about, and he said, I don't usually like to interrupt a closing, but this prosecutor is misstating the law. She's not accurately telling this jury what the law is, and asked the judge in front of the jury to tell them that the instructions are going to come from the court. So the jury knows in that moment, if they're paying attention, which they really were, Vinny. I was in the courtroom today just seeing how engaged and attentive most of them are. They will know that this part is really important, and we're going to have to be paying attention to these jury instructions to figure out what that's going to mean and what it looks like. But it may come down to some things that they have to interpret based on what they've seen and what the letter of the law is.
Wow. Okay, let me bring the think tank. Don't go away, though, Julia. Joining us tonight in Los Angeles, California, Deputy Public Defender for Los Angeles County, Philip Dubé. In Minneapolis, Minnesota, Criminal Defense Attorney Joe Tamburino. And in Atlanta, Georgia, Criminal Defense Attorney Michael Bixon. Great to see everyone tonight. Michael, I have to start with you, Michael Bixon. You're in Georgia. You're in the hot seat right now. You are on the hot seat. To me, this is...
lucky me.
We are in a position here where the prosecution and defense are disagreeing in front of the jury in their arguments about what the citizen arrest law is in Georgia. What is this jury supposed to do?
I think they're going to have to wait for the judge's final instructions. And let's be clear, this is a really poorly written law, and it's not the only one. I mean, it happens all the time. You read through all the statutes and you look at them and you go, my God, who wrote this? and this is definitely a problem with this one as well. I mean, it's since been repealed. But what they're dealing with in court now is a very poorly worded statute. And because of that, it's rife for misinterpretation and a lot of issues. And, obviously if there's a conviction, maybe appeal. But I think eventually the jurors are going to have to learn to listen to the judge in terms of, how the judge describes the statute and his in the instructions in which they'll take back with them when they're actually making their deliberations.
Philip Dubé, if this jury believes that it's in the immediate knowledge of, it seems clear to me, I don't know if it was in their own minds, they had all this knowledge that something was going on, that he had been in the house several times. Will that be enough to get over this first hurdle? I know there's two hurdles for the defense, but do you think that's enough to get over the first hurdle, that somehow this jury may think it's a reasonable argument that this was a lawful attempted citizen's arrest?
I think it's going to be a problem, and I'll tell you why. Probable cause cannot ever go stale. It has to be fresh at the time of the pursuit. You don't get to factor in past activity that could, somehow play into your determination or into your strong suspicion that a crime has been committed. You have to look at that moment in time. And frankly, the defense should have asked for a pinpoint instruction for the jury to define probable cause, and that is a state of facts, if you will, that would lead a person of ordinary prudence to believe and conscientiously entertain a strong suspicion of a suspect's guilt of a crime. And the way this instruction is written and the way the statute is written, they don't really define probable cause. So I think that's what they need to focus on. What state of facts would an ordinary person, if you will, standing back objectively, rely on to say, I believe Ahmaud Arbery has committed a crime? And I think that's where they need to focus their attention.
Joe Tamburino, if this, let me change things just a little bit, right? Hypothetical, here we are. This is a tough legal question. If a police officer had seen all the videos and had heard from English that, yes, some stuff had been stolen from my place, and to me it seems like this would be, oh, this is the guy we've been looking for, the guy from the videos. Is that enough? Would be enough? Is there any difference? Would it be enough for police versus these citizens trying to effectuate this citizen's arrest? These wannabe cops of the neighborhood, the McMichaels. Is it enough here for probable cause, knowing that, hey, that's the guy from the videos?
It might be enough for a trespass, but not a burglary, not a felony. And I think, Vinny, what you hit upon is really important. These guys aren't cops. They're citizens. Police can go back in time and develop a full case. And
so you're saying there's a difference.
Cause.
You're saying there's a difference for this probable cause standard for if they were police officers versus citizens.
Absolutely. And that's why the citizens arrest law in Georgia at the time, which has since been rescinded, clearly states it has to be in your presence or immediate knowledge. It doesn't say in your presence or after you as a citizen conduct your own investigation and can go back in time 6 months and build a case. There is a difference between being a licensed police officer and being a citizen. The citizen arrest laws, what the defense is doing in this case is they're really trying to stretch it and drive a truck through this. I don't think they have a case. I think this is the best that they can do. They clearly were acting outside of the citizens defense law. Arrest law, and even when we get to self-defense, they were clearly provoking the situation.
We're getting there. You almost did my tease for me, Joe Tamburino. Look at that. Stepping ahead. That's good. Because this is the first hurdle. There's a second hurdle, which would be the self-defense. We're going to talk about that when we come back and get more insight from our think tank with us the whole hour and Court TV legal correspondent Julie Janae. We'll be right back.
What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not even an ID. They want you to believe that he is the danger to them. And Mr. Rubin said it in the opening statement. He was scary. So here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say, I was acting in self-defense. And there's 3 of them, and it's the law. This isn't just something made up. There's 3 of them in the law, okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the third one is if you provoke somebody so that they defend themselves against you, and then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law.
There's the prosecutor making the arguments against the second part of the defense, right? The first part is citizen's arrest. The second part is self-defense. Well, let's take a listen to what Travis McMichael's attorney had to say about that.
He's charging with his feet. Travis is trying to brace himself. Is there any question that Ahmaud Arbery had his hands on this firearm? Any question at all? Travis, in his interview, told you, I was under shock, I was under stress, I don't know. If he had his hand on the gun, I think he did. I think he did. I think he had my shirt, I think he was punching me. Travis is in a state of disrepair. There is no question that Ahmaud's hands are on this gun, and the medical examiner from that stand told you that if Ahmaud Arbery is grabbing this gun and trying to pull it away, that as the gun gets pulled out of his hands and fired, it could fire right on that wrist and shoot into the chest and go across the body. Pull it straight out. No question. This is about this gun. Travis turns into Ahmaud, trying to use his entire body, pulls the end of the shotgun away from him, gets pushed across the road into the grass, and the second shot goes off. Here's the plume, and it's believed that it didn't hit Mr. Arbery. Travis, coming out of the grass now, trying to yank this gun from Mr. Arbery. Again, trying to yank it away from him. Ahmaud's hand still on it. Ahmaud's fist now raising. Is there any question that Ahmaud Arbery is assaulting Travis McMichael right before that third shot? Not one single bit of question. And that third shot goes off. And these two men end where they started, face to face, looking into each other's eyes. Never a word being spoken by Mr. Arbery. And it is absolutely horrific and tragic that this has happened. And again, this is where the law is intertwined with heartache and tragedy. You are allowed to defend yourself. You are allowed to use force that is likely to cause death or serious bodily injury if you believe it's necessary. At that moment, Travis believed it was necessary. This is a law that is for a person in Travis's situation.
Okay, I keep saying it. There's two parts: citizen's arrest, self-defense. If you don't get past the citizen's arrest, you don't even get to this. You don't even get to the self-defense, from my perspective. I think it's impossible. Jury can never get there. Let's bring back in Julie Janae, Court TV legal correspondent, who's in Brunswick. That's why I don't even want to talk about the citizen's arrest affecting the self-defense. But if this jury believes that this was a lawful citizen's arrest, can you summarize for us or give us what prosecutors, did they make an argument, that would overcome a lawful citizen's arrest as well for self-defense here, prosecutors?
Well, it's really in conjunction with citizen's arrest being debunked, because they are saying that there was no lawful reason for Travis McMichael to be going after Ahmaud Arbery. In that instance, he would become then the initial aggressor. He's the one who's going after Arbery, and they made it very clear for this jury that if you are the initial aggressor, then you can't claim self-defense. That's why citizen's arrest is there and required for this defense in order to get around the fact that these three men were going after Ahmaud Arbery, and it's very clear on the video. These jurors were doing a lot of writing during that explanation of self-defense, both by the prosecution and the defense. And I also noticed them leaning forward a lot more and being even more engaged when Jason Sheffield, the attorney for Travis McMichael, was showing the portion of the video that we really can't see. What happens in front of Travis McMichael's truck after Ahmaud Arbery turns that corner and Travis goes out of sight because he's also in front of the truck. And And Sheffield used on a loop a portion of that video just showing Ahmaud Arbery going around that corner over and over again. And these jurors were really peering at that, seeming to want to understand what is happening there. If there's anything that they can see that lets them know who is the initial aggressor or who might be provoking the other, because that's going to be a really important part if they cross over that citizen's arrest hurdle.
Let me ask you one of the questions of fact in this case and how it came out during the case. When is the first time that Travis McMichael raises his weapon towards Ahmaud Arbery? Is it at the moment of the shot, or does it happen before that?
It happens before that. It's when Ahmaud Arbery is still running towards the truck away from Roddie Bryan. They're about 40 feet apart, 30 to 40 feet apart. And it's a still image that the prosecution has shown this jury. There it is, of his gun being raised, pretty grainy there. But Travis McMichael admits that he did have it raised because he thought Arbery was going to come at him. And then he says he then returned it to port of arms, using a military term about how he was holding the gun when he then disappears out of sight on the video. So the initial time that he raises it and points it is when there is distance. And the defense called it the 21-foot rule, that Travis was taught that if someone gets within that 21-foot distance from you, then that's when they could easily get your weapon and use it against you. So you need to make sure you don't let them get within 21 feet of you. And they admit today he wasn't quite within that 21 feet, but he was headed that way because he was running.
All right, let's get more reaction from our think tank tonight on the second big issue for this jury, which is self-defense. Let me ask you, Joe Tamburino, self-defense, if the jury is focusing on that loop or the part of the video where Ahmaud Arbery's going around the truck, or the part where you don't see him in front, if they're focused there, that's a major, major victory, I would think, for the defense, because now all of a sudden they're trying to decide self-defense, and they've kind of thrown out, maybe they've already agreed that, yes, this is some sort of a lawful citizen's arrest.
Yes, if they were just looking at that frame, but they would have to go against reality, because before that frame, it's clear that McMichael was pointing the gun at Mr. Arbery, and that was provocation. And I think the prosecutor, Ms. Dunikowski, which, by the way, she's a woman prosecutor. Of all these major cases that have happened this year, she's the only lead prosecutor who's a woman, and she did a fabulous job. She did a better job than any of the men in Chauvin, in Rittenhouse, in Durst. She did a fabulous job. But you're right. If all they did was look at that one clip, sure, they could have a reason to decide self-defense, but you would have to negate all the other facts that happened before that.
Yeah, and Joe, we just should point out, you know how good female prosecutors are, don't you?
Absolutely.
He's married to one. All right. Philip Dubé, let me ask you, on this issue of self-defense, if this jury is zooming in on what's happening in the front of that truck, is that a problem for prosecutors?
Yes, because obviously what they're focusing on is what Ahmaud Arbery did to put Travis's life in danger. Remember, he testified that he tried to yank and pull the gun away from him. He got the hand on the gun. And if a jury really believes that, then it doesn't really matter whether or not there was probable cause to even make the arrest. All that really matters is that there was reasonable suspicion to detain. And I think we can all agree that, you know, they didn't just come out of the firmament, come marching out of nowhere, just trying to take down an unarmed black kid. Their hackles were raised, if you will. They had some suspicion, they had some curiosity. And if he is now reaching for the gun and he is now in front of that vehicle, he's put himself in a position now where the truck or the car has to stop, and now everybody has to get out of the car, and now you have a confrontation. So what are you supposed to do? Are you supposed to just stand down, just sit in the truck or in the car and do nothing? Remember, if his suspicions are valid, he still has the right to investigate, and if it's a felony, to take him in on it.
Let me ask you, Michael Bixon, what do you think this Georgia jury does? I mean, at the top of the show, I talked about the big picture. You know, I looked at it in a very basic term when it comes to self-defense. Who started it, right? How do you think this jury is going to look at this entire situation? Will it be that basic that their gut tells them, listen, you started it, you don't get to finish it with self-defense? Or do you think they really get into the weeds and kind of get into, okay, well, was there provocation? Was this a lawful citizen? Where do you think this jury goes with all this?
From what we've seen in the trial, I mean, it definitely looks like they've been attentive and they've been focused and paying attention throughout it. I absolutely do think that they're going to look at the law, they're going to look at the facts and apply it to each other. I think, you know, if you just look at this isolated camera incident, and if you're just paying attention to that, yeah, I do think that it looks good for the defense. But in the context of everything, in the context of whether or not there was even a lawful arrest attempting to be made, no, I don't think it's looking good for the defense at all, and I do expect a guilty verdict.
You know, I'll agree with you that I think that's the problem, right? You got to look at the whole thing. So something doesn't seem right here. It just doesn't seem right, and that's a problem when it comes to self-defense. You've got to be in the right because you've got to say, yes, this person deserved to die. Right? That's ultimate justifiable homicide. That's what it is. This person, yeah, it's this person deserved to die because of the circumstances, and that's not what most people's gut is telling them. People that I've just told the story to. Again, a trial is a whole different thing. You guys are staying with us. Julie Janae is going to leave for just a short while, but when she comes back at the top of the hour, Julie Janae is going to tell us about the moment today that everyone's talking about when Ahmaud Arbery's mom bolted from the courtroom. Julia Janae was there. She'll have those details. Also, the attorney for Ahmaud Arbery's family will join us as well next hour. But when we come back, we're going to talk about the wild card in all of this. Kevin Goff, the attorney for Roddie Bryan. How is that going to play into all of this? And how could what he said today affect everything else? That's next. Welcome back. Still with us, our think tank. And we've got great ones here. Philip Dubé, Joe Tamperino, Michael Bixon, all with us. Locked and loaded. Here we go, guys. I'm going to play for you now Kevin Goff. He's been the wild card throughout. But I thought he made a pretty compelling argument in his closing today in front of this jury. And it was not just about his client. It seemed that he was kind of throwing the McMichaels under the bus while trying to prop up his client. Take a listen.
When did Roddie Bryan know the McMichaels brought guns? When did Roddie Bryan know Travis McMichael would shoot Mr. Arbery? And at that point, what could Roddie Bryan have done to stop it? The inconvenient truth is that Roddie Bryan did not know and could not know that these men were armed until moments before Mr. Arbery's tragic death. He did not know and could not know that Arbery would be shot. And by that time, sadly, there was nothing Roddie Bryan could do to prevent this tragedy. Roddie Bryan didn't shoot anyone. At the time of the shooting, he was some distance back. He was armed only with his cell phone. Isn't it time, ladies and gentlemen, that we send Roddie Bryan home?
All right. Two things. He's kind of like, he's throwing him under the bus. He can say, well, it's your job, but that's what he was doing there, Michael. Do you think that will be effective? I mean, everything he said was true.
No, it absolutely is. And I think that he does a good job at trying to distance his client from the other two defendants, which is absolutely crucial to his case. So I totally understand what he's doing. I think he did a great job at it, and I can respect that.
What do you think, Philip? Is this enough to get him out of liability for the death of Ahmaud Arbery? Saying, listen, I didn't know they brought guns here. He had no idea. He never saw the guns. He didn't see the guns until it was too late. And there's nothing he could have done anyway.
Yes, I think he had to do whatever he could to detach himself from their situation. I think he thought he was going to be the Good Samaritan and try to preserve evidence with the phone. I don't think he ever thought for a second that he was going to be embroiled in a murder prosecution. And I don't think there's any nexus between him filming what went down and their decision to take a gun out and shoot Ahmaud Arbery. I just think it's too attenuated to hold him liable for the homicide. I think the worst case scenario for him may be, and this is just a maybe, a false imprisonment. And even then, I'm not even sure it rises to that level because he didn't do enough really to put a restraint, any physical restraint on Ahmaud's liberty.
Joe Tamburino, I know here in Georgia, the felony murder prosecutor's best friend. I've seen it used in cases where I was like, wow. And I don't know if the jury knows, but it's the same as malice murder. Your life without possibility of parole, you're going away. Do you think this was enough to get him out of there, to explain to this jury that he didn't even, how could he be party to a crime when he never spoke to the guys, didn't know they had guns, didn't even know why they were chasing them?
Well, I agree. I think he's got the best shot out of all three defendants. I don't think the McMichaels are going to win. I think they're going to be convicted. Mr. Bryan does have the best shot, and his attorney did three good things. First, he clearly pointed out that Mr. Bryan did not know what the McMichaels were going to do. Second, that Mr. Bryan cooperated with the police. That was very good. And third, he really humanized his client and made him sort of look like a simple guy that, he's not a wordsmith. He's got this real heavy accent. He doesn't speak clearly. He's just a plain guy who got wrapped all up into this. So I think he did a good job, and he's got the best shot for an acquittal.
Michael Bixon, you practice in Georgia. I've seen it many times. This felony murder in Georgia is used all the time effectively by prosecutors. What are your thoughts here?
If they get him on something like a false imprisonment charge, I mean, that's it. He's done. I think the other ones are, like in terms of him being a party to a crime, it's a stretch. I honestly do, just based upon the facts. But with something like false imprisonment, I could see that. And if they get him on that, they could get him on the murder charge. So, I mean, it definitely is a possibility. But out of the three, I do think that he's in the best position right now.
And Philip, when you talk about the false imprisonment, if the jury finds that false imprisonment, I mean, it seems that the false imprisonment leads to his death, and that would put him on the hook for felony murder. Do you think a jury, though, could find him guilty of a felony but not guilty of felony murder?
I think it would be pretty tough, to be honest with you, because if they find him guilty of the felony, I think that legally he's probably liable for the murder under Georgia law. What's interesting is California did away with this. We did away with aider and abettor murder liability in the felony murder context. The only way you can be convicted of murder as an aider is if you're the actual killer, or if you actually intended to kill, or if you acted with extreme reckless disregard for human life. And this guy didn't do that. So, and unfortunately, that's not the law in Georgia, so we'll see what happens. But I agree with the think tank. He's the least culpable.
All right. We got one more segment with the think tank, but I got to let you know about another great case that we are tracking here on Court TV, an important one that actually happened in the middle of the trial of Derek Chauvin out in Minneapolis. It's Minnesota versus Kim Potter. There she is. She was a police officer. She had been part of a motor vehicle stop of Dante Wright. We've got a picture of Dante Wright. She ends up shooting and killing him while yelling, "Taser, taser, taser." She has her service weapon in her hand. The video is about 1 minute. I'm going to show it to you now so you can see what this trial is all about. Minnesota versus Kim Potter. The trial starts November 30th. That's the Monday after the Thanksgiving weekend. Opening statement scheduled for Wednesday, December the 8th. Court TV cameras inside the courtroom for that one. When we come back, folks, we're going to talk about what happened last week and what happened Friday in Kenosha. More reaction to the not guilty verdict for Kyle Rittenhouse, including reaction from Kyle Rittenhouse himself. As you saw here on Court TV, a Kenosha jury found Kyle Rittenhouse not guilty on all charges. And in his first post-verdict interview, Rittenhouse spoke to Fox News' Tucker Carlson and says he's not racist and accuses the prosecutor of misconduct. Take a listen.
This case has nothing to do with race. It never had anything to do with race. It had to do with the right to self-defense.
Right.
I'm not a racist person. I support the BLM movement. I support peacefully demonstrating. And I believe there needs to be change. I believe there's a lot of prosecutorial misconduct, not just in my case, but in other cases. And it's just amazing to see how much a prosecutor can take advantage of somebody.
All right, your reaction tonight to that verdict. That was the reaction of Kyle Rittenhouse, at least part of it. Amy, with our 13th juror comment of the day, writing, the jury took their time, clearly looking through everything and taking their job seriously. This was a tough case at times, but I 100% agree with the verdict. Now I hope moving forward, he is put on a good path and realizes how precious his life is. What he does with that life is now on him. Joe Tamburino, I want to ask you, first of all, one thing that Kyle Rittenhouse was talking about or reacting to was race. Was that trial about race?
Well, it started with race, obviously, because of the Jacob Blake shooting, but really it wasn't about race because all of the players were white. Mr. Rittenhouse was faced with white assailants. He shot at white victims. So, it started off with the Blake shooting, which does have complete race involved in it. But in terms of Mr. Rittenhouse's specific situation, no, it was not about race.
Philip Dubé, the other thing that Kyle Rittenhouse spoke about was prosecutorial misconduct. Your thoughts about that concept, first in his trial and then in our system of justice?
Oh, he's absolutely right. He's very astute. I mean, look what that prosecutor, Mr. Binger, did. One of the cardinal sins is you never, ever, ever, ever comment on an arrestee's post-arrest silence, ever. And to put that before a jury is designed to imply guilt and to imply consciousness of guilt when in fact he had a constitutional privilege not to say a word. And that is criminal procedure 1A. And for a prosecutor to insert that, I thought was really terrible. If Kyle would have been convicted, I could actually see a judge granting a motion for a new trial based on prosecutorial misconduct, vacating the verdict and or dismissing with prejudice because it was so egregious.
Michael Bixon, what did you see during the course of this trial? Was he treated differently in any way? Was this about self-defense? Was this about race? What was this whole thing about?
I mean, from the beginning, I thought it was a self-defense case, and a great one at that. I'd love to have a self-defense case this good compared to some of the ones that I've had. So from the beginning, I thought it was a great self-defense case. I did think that there was a lot of prosecutorial misconduct from the beginning to the end of this case. And not just that, but a really poor job of prosecuting this case on the state's part. I thought that there could have been a lot better witness preparation in advance for a lot of the lines of questioning that they went down. And oftentimes I was sort of shaking my head and questioning as to what are they doing here. So I'm not surprised at the verdict. I think it was the right choice here.
I want to go to one more comment from Tristan, who says, these people would not be dead if a 17-year-old had not had a weapon. What is a 17-year-old doing with a weapon like this? He was a minor. Why are the parents not being held responsible for his actions? What about the person who bought him this gun? He had no business being there in the first place. The only thing I can say to that is the person who bought him the gun, He was convicted of a crime. He testified for the prosecution. But in the end, the judge found that a 17-year-old was permitted to openly carry the AR-15 in the streets of Kenosha. And that's the law. They don't like the law. They got to change it in Wisconsin. Great job tonight, Philip Dubé, Joe Tamburino, Michael Bixon. Appreciate your insight, your experience, and of course, your valuable time tonight. We'll see you again real soon. When we come back, Julie Janae live in Brunswick. In Brunswick, Georgia, all the evidence and some of the arguments have been made in the death of Ahmaud Arbery murder trial, and soon the case will be in the hands of the jury.
They shot and killed Ahmaud Arbery. They all acted as a party to the crime.
Ahmaud Arbery was not an innocent victim.
But there's still no false imprisonment here as a matter of law.
We're talking about probable cause, totality of circumstances.
We are live in Brunswick with the latest.
This jury appeared engaged, alert, and thoughtful as they heard closing arguments from the state and defense. Will have how much more they have to listen to before they can go to deliberations, and the moment in court that sent Ahmaud Arbery's mother out into the hallway.
On the docket tonight in Hennepin County, Minnesota, the shooting death of Dante Wright. Former officer Kim Potter yells, "Taser, taser, taser," but shoots Wright with her service weapon. Was it an accident or was it a crime? In tonight's Unsolved Case File, the murder of Dominic Arca-Jones. On October 20th, 2018, Dominic was shot and killed just blocks from his home. Tonight, we ask for your help in getting justice for Dominic's family.
We have no closure. And right now, I mean, we know he's gone, but it still felt like he should be walking through this door.
And more reaction tonight to Friday's dramatic conclusion to the Kyle Rittenhouse trial. Tonight's 13th juror question: what did you think of the jury's not guilty verdict? Go to our Facebook pages and tell us what you think. This hour of closing arguments starts right now. I'm Vinnie Politan. Great to have you here tonight on Closing Arguments. And it was closing arguments today in the case against the three men accused of the murder of Ahmaud Arbery down in Brunswick, Georgia. And you can watch them, right? You can watch those arguments all day long right here on your front row seat to justice. Some people sometimes will watch a stream of the arguments, but you know, you get like half the story if you do that. What you need is a little more insight into what is happening. You need someone who knows the facts of the case, someone that knows the law, that can put everything into context, and someone who is actually inside the courtroom, who can see things that our cameras and microphones may not be picking up. That's how you get the whole story. And we're going to bring that to you right now. Court TV legal correspondent Julie Janae is joining us live from Brunswick, Georgia. Julia, great to see you. Busy day for you inside the courtroom for these hours and hours of arguments. But tell me a little bit of what you saw in the jury, with the jury, in the gallery today as we all were watching these arguments.
Been a really busy day today, not only for these parties, but the jurors as well. And looking at them today, first of all, it's interesting to see how they are separated. They're not just all in the jury box viewing this evidence.